Hello and welcome to the Rogers Brief. I'm Adam Rogers. Today I'm going to talk to you about the underappreciated significance of an ongoing court battle related to information dealing with the mass shooting and why I think it's important. As always, thank you for watching, and if you find this video or these videos to be interesting or insightful, please I'd invite you to share, like, and subscribe. Now, in advance of the Mass Casualty Commission proceedings, which are now set to begin in January and February of 2022, there is already a court battle ongoing, taking place over the public's access to information. And the battle is now between the police on one hand and the media on the other, who are fighting for this information to be disclosed. And it all has to do with a series of search warrants which were issued soon after the tragic shootings, relating to the gunman's properties in Portapeak and in Dartmouth. And so when the police apply for a warrant to search any private property, they need to apply for that warrant, and when they do so, they need to provide the justice of the peace or the judge that might issue the warrant with full disclosure, full information, all of the notes, all of the information they have about their investigation. And this information can be, well, it's presumptively disclosed to the public, but what happens often is that the information is actually sealed. There's a concurrent application when they make the application for the search warrant. At the same time, they also make an application to seal information, and there's some valid reasons for this. It can be sealed if there is information in there that might reveal the identity of a confidential informant, if it might compromise an ongoing investigation, if there's any information in there that might prejudice an innocent person, or if it might harm an ongoing investigative technique, typically undercover operations, if there's an undercover operation that might be harmed. And then any other valid reason is also one of the reasons listed in the criminal code. Now, that last one is typically to do with trial fairness issues, but anyway, all of those categories have their own discussions. Usually, it's not uncommon for an application to be made to unseal the warrant information, but that's usually done by a defendant, whoever's property might have been searched, might be making a charter challenge saying that the search warrant should never have been issued on the information that was available at the time. In this case, it's different. It's the media that is making the application so that they can report on what was done during the investigation and during the active time when the investigation was, when the police were dealing with the active shooter. As you might expect now, when the police draft these applications for search warrant and have parts of it sealed, there is a tendency, and they're very susceptible to overreach by the police to have more of the information sealed and redacted than is necessary. The police work with the Crown Prosecutor and to have that information done, and it's very important that the Crown Prosecutor not be an agent of the police, but rather be push back and ensure that what should be disclosed is. And that's not always the case. Now in this case, the application has been ongoing, like I say, for the last year. There's been many court appearances done already. It's taking tremendous resources, a number of lawyers involved from media organizations. It's taken a judge basically out of circulation up in Port Hawkesbury. They've been using the same courtroom as been used for the Desmond inquiry, which is designed to hold up to a dozen lawyers with technology to bring in others remotely. So I've reviewed the informations to obtain, which is what the documents are called. After some of these applications, some of the redacted information gets released, and we see what had been blacked out. And it strikes me that many of the items that had been blacked out and have now since been released, the information is quite benign, or it's information that we already have from other sources. So when you read through this from a lawyer's perspective, it leads one to think, well, maybe the police have, in the first instance, redacted or blacked out more than they should have. Why is this an issue? Okay, so we have the Mass Casualty Commission proceedings which are going to take place, and one would presume and may fairly presume that during that process we're going to have all of the information. Well, okay, if we're going to have all of the information in just a few months' time shown to the public, why would the police be fighting the disclosure at this stage? It's one question, or one way to look at the question. The other way to look at the question is, since the police are fighting the disclosure so vigorously at this stage, isn't it likely that they are going to continue to fight that disclosure throughout the Mass Casualty Commission proceedings? Now, that could be a real problem, and that may in fact be the cause of this 4-month delay that we're now seeing between the original start date of the Commission proceedings, which was supposed to be the end of this month, October 26th, and now we hear those proceedings are not going to start until February. That may be the cause of it. Now, if this is the problem, and if this disclosure continues to be withheld, it's going to be very difficult for the Commission to actually get the answers that we are seeking, that the public is seeking. One thing involved in this is one of the factors that the police and the Crown can use to withhold information is if it was to prejudice an innocent person. And so the police, the Crown, have argued that some of this information would harm the victims, would re-victimize them. We've heard some pushback from the families that say, no, we just want to get the truth. They don't wish to be protected in that manner. They just want to know what happened. So we'll see how that dynamic plays out over the next few months with the Commission proceedings. And time will tell. But when we see the RCMP and the Crown approach to disclosure in this case, it tells us that there's going to be an ongoing problem with disclosure during the Mass Casualty Commission. So that's something to watch out for, and the ongoing court battle is indicative of that future difficulty. So keep an eye on that and in proceedings in the meantime before the Commission hearings start in the new year. Okay, so that's what I wanted to talk about today, an important issue, something that's going to crop up again and again during the Commission proceedings, I suspect. So thank you for watching this, and we'll see you next time.